The Idaho 4 case continues to just raise all kinds of eyebrows. In the Brian Kohberger case, so much is missing, we don't know what's going to happen with it.
But what exactly is missing? There seems to be some confusion about what we're looking for and what Ann Taylor hasn't received in the Kohberger case. I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have Forensic Frenzy on. Forensic, how are you doing?
Welcome.
Great. How are you?
Good. Thank you so much for joining us today. So Andrew has put together a PowerPoint, and we're going to go over some of the recent developments and a little bit of a continuation from where we left off after the big shush or the big hush moment.
Forensic, do you remember that hearing that they had where they argued for 25 minutes whether or not to show the PowerPoint?
Yes, I do.
Yeah. Do you want to do that or not?
Well, I do not. I just want to show the PowerPoint.
Forensic and Lainey, we have 5 red flags this week on missing documents in the Kohberger case. And as you know from that hearing that was held earlier in the month, Ann Taylor, Brian Kohberger's defense attorney, was listing documents when she was hushed. And there's no question she was hushed. But here are the documents that she was listing that she doesn't have. She said she doesn't have all of the cell phone information. She doesn't have the cell phone tower information. She doesn't have the drive test information. We'll come back to that. She doesn't, really importantly, have the video supporting the probable cause affidavit. She only has parts of it here and there. Audio is missing. She only has parts of it. And she does not have the full cast report. Again, we'll come back to that. But now, Forensic, I'm going to allow you and Lainey to answer this question. Right before Ann Taylor was hushed, she said, I'm missing the speed test and the drive test. What is she talking about?
I'll let you start out, Forensic, and I will say what I think that is after.
Okay. So what I think she's talking about refers to the existence of information that would show how quickly your cell phone, takes in the message and then sends out the message. So it just doesn't send from me to you. It sends from me to like a receiver that repeats it back out to you. And there's a process there. So how quickly does it all happen? And when you receive that information, is there a delay? And if so, how long? That is speed test. Now, drive test would be the same thing, but instead of me sitting in my house idle or walking outside at a very slow rate, I would be doing something a lot more rapid. For example, in a vehicle, or like I'm on a train where I might hit multiple towers very, very quickly. What do you think, Lainey?
So I kind of agree with you on the speed test. I guess one of my thoughts with this is I was questioning, is this related to the vehicle itself? Because something we've talked about on the podcast prior is how cars can have some type of information. So is this potentially related to how the car is moving, like the speed, and then like the drive test, is that showing where it's kind of going and connecting to GPS or connecting to satellite? But I also agree with you. It could also be a speed test, in where the sense that most people are familiar. We check our ping, and like if you're having a bad internet connection, you can go do like a speed test, and you can see, like Forensic said, how fast the information is going back and forth. With the drive test in particular, if we're talking about in an electronic sense and not vehicle related, because that I don't know too much about, I was curious if the drive test is potentially related to the fact that Ann Taylor keeps saying she doesn't have the correct video and that bits and pieces are missing. And I'm wondering if the drive test is to check like the hard drive that she was given that has these 50 whatever terabytes of information, to see if anything was tampered with or how things are running and if everything's going appropriately. Sometimes with things like videos, things like frame rate can change, and were these materials, tampered or anything. So it could be different things. It could be a multitude of different things. There's so many words for everything. So are we testing a hard drive? Is it related to the car? Is it related to, like you said, rapid movement when you're in the car, when you have your phone connected to the car and it's GPSing and it goes into like drive mode? Those are just my speculations.
I have an interesting, I'd like to run off of that. So you could be correct about the car. Just before we did this episode today, I printed this out. I'll put it up kind of close. So it's the Electronic Frontier Foundation, and they are like a foundation that tells you basically what your rights are. And they talk to you about, they're a nonprofit, and they just talk about digital privacy, free speech, and, you know, technological innovations and how those things can have ramifications on your life. So this one is cell phone location tracking, or CSLI. Okay. And this is what it says. A cell phone's location can be tracked through, obviously, the cell site location or global positioning. So CSLI or GPS. Okay. And they go on and they talk about how you can get this information, triangulate the person. The second page of this document actually talks about license plate readers. And
Mhm.
on that license plate reader, and it does talk about the fact that they have historical data on all of our license plates if we have readers in our areas, or if we've ever driven through an area with readers, and they can actually go back and verify if you drove through an area a year ago. Some of these places more than that. So it's very interesting, and you actually could be right. Drive test could potentially pertain to the automatic license plate portion of this, and then it would be tracking where his vehicle actually went, side by side with where the phone went. And
So,
that's more like the prosecution story that they're trying to build.
so is that why it would take so long? Because they're using this technology you just talked about to go back all the way to November 13th of 2022, and all of the cameras that they did have on the 22,000 Hyundai Elantras, and make sure that it was his car that went by the pot shop or the weed shop. Is that what they're doing?
It sounds like it. It sounds
I
like it.
hope it's not. I only say I hope it's not because the government is like notorious for having like really bad, I feel like, technological structure. So the idea that it's taking so long to find something that the one of the first information should be like the license plate number and then the time and date, like it should be something easy to look up. So I want to tell myself that it's not that, only because that would be just ridiculous on the back end standpoint. But I also think that you're probably right with that. It's like I don't want to believe it, but like also I think it's like very
Well,
believable.
Devil's advocate, I mean, I have concerns about the government having all this technology, but forensic, back 10 years ago when the Boston Marathon was bombed, wow, within no time at all, they had all of the videos, and they eyeballed the Tsarnaev brothers. Now, I know it's different. Boylston Street in Boston has a million businesses. I know, I went to college around the corner from there. And, so I know it's very different. But, the bombings were on a Monday, and they had the Tsarnaev brothers in their scope within 48 hours. So what is taking them so long?
Well, I have a question.
Yeah.
I also wonder what's taking them so long. And I wonder how long it really did take them to determine what car they were looking for, despite maybe not knowing the person. And I only say that because I want to go back to the 22,000 white Hyundai Elantras that were
Right.
in the area.
Mhm.
But if you remember, there were 22,000 white registered Hyundai Elantras on November 13th of 2022. When these crimes occurred, the defendant's Elantra was not registered, not in that area. It was registered in Pennsylvania.
Right.
So it wouldn't have been one of the 22,000 that they were going through. They would have been looking for one that wasn't on the registry. So the number 22,000, they just threw that out there to make it look like they had to go through 22,000, but they didn't. From the 13th until the 18th, his vehicle wasn't registered in Washington.
That's right. Yeah.
It was not one of the 22,000 for the first 5 days. So, and they
And all-
knew that in the first 5 days.
And all they really had, according to the earlier part of the time period discussed in the PCA, was that it was a white Elantra, and they even had the wrong year, and it was a white Elantra that didn't have a front license plate. So, they didn't have a lot to go for. It mystifies me why it took so long. And speaking of taking so long, the cast report. What is taking so long with the cast report? And I'm trying to bring this up right now, and I'm having zero luck. Here we go. I don't understand what's taking so long with this cast report. And just for our viewers who don't know what a cast report is, The FBI has a cellular analysis survey team. That's the acronym for CAST. The report provides historical cellular location information by analyzing cell site sector information, plus timing information available in a cell network. It's a cell activity report. And the reason I don't understand why it's taking them so long is I followed the Murdoch trial fairly closely, and Paul and Maggie Murdoch were slayed on June 7th of 2021. Alex Murdoch's trial started in January 23rd of 2023. That's a period of 1 year and 7 months. And forensic, we're nearing that in the Kohberger case. It's now, as we record this, it's been 1 year and 6 months. And Ann Taylor says she only has a draft of the CAST report in the Kohberger case. So my question is, if they were able to get it, and I think they had it in advance of the Murdoch trial, not only did the prosecutors have the full CAST report, they also had a witness from the FBI who cooperated and came forward and went on the stand. And I actually took notes. The FBI expert went on the stand and explained in much more detail than I just did how they put that report together. So I don't understand why there's only a draft in this case. Do you?
I don't really understand. I know that there's obviously an editing, okay, and writing. There's your drafts and then your final. So I assume that would be the same thing here. But I'm wondering if when she says draft, perhaps she just means like this. They've given me a summary, and it's just not. I can't just accept their summary. I wonder if that's why it's taking so long to get her a full report, is because they've given her a summary of their full report, and that's all they're willing to give her. But she wants their actual full report. So I wonder if the term draft is causing a bit of confusion, because maybe she's using the word draft and it seems like it would be like a starter build up to the final report. But in actuality, maybe what it means is that they've given her a summary and she doesn't want that. And I can understand why she would not want that. A summary is kind of like what we've been given in the PCA. And there's nothing but questions to be asked from that. So if that is what they've given her, is some kind of like draft summary, I can understand why she would be unsatisfied with that. And why it would be taking so long, I simply don't think they want to give her the full scope of what they've done there.
So do I have this correct, that what the defense is waiting on is not only the CAST report, but the cell location data and the speed test and the drive test? Are those all things that she is waiting on the FBI to provide to her?
Yes. Yep.
So why do you think it was that Ann Taylor was shushed by Ashley Jennings when she listed all this stuff, and Bill Thompson had said something about a TUI letter? What was that all about?
Well, I suppose that she was listing things we've heard before in the past. And then there was something that she was about to say, the verification of something. And that's where she was either shushed or told judge, and the judge was asked to shush her. But either way, the same message. So there's verification of something that she is looking for, that either she's being denied or she is saying they didn't do the verifying. And that her investigator will show them that had they conducted the verification they should have, that they would have come up with other results. So I'm not sure about the shushing, but the TUI letter, we have talked about that before. And they've mentioned that the TUI letter was dated November 28th of 2023. Okay, so they would have been given this letter and they went back and forth in the February 28th, 2024 hearing about whether or not Ann Taylor's experts and investigators were going to have access to the IGG. And Ann made it very clear her experts were already given access. It was her investigators that she was trying to get access to the information. Then the argument became, well, you need to name those investigators in public record.
Right.
And the argument from Ann was, we haven't done that in some instances, and I'm not really sure why we need to now, but I will. Okay, so now at that point, they said, fine, then name them. And we ask that they only be given access to that TUI letter. So Anne does have the TUI letter. And apparently it's supposed to describe how they got to Brian and why they arrested him. But what Anne must be saying is there's something missing from this letter.
Right.
Because now we are resubpoenaing the FBI and there's mention of a whole new TUI request. So there is something there, possibly the drive test and the speed test. There's something there that is not complete. And in its completion, her argument is that you would have come to a different outcome and you would not have arrested my client.
Right. Well, let's back up a little bit and talk about TUI, because he talked about a TUI letter, and I don't know if he was spitting on the floor and going patooey or what. I think a lot of our viewers might not know what we're talking about. A TUI process is a process by which a mere mortal or a defense attorney or a prosecutor can request information from the federal government. It's a direct kind of a request. It goes around discovery. It doesn't have anything to do with that. You request information from the federal government. And then, although the theory is that, oh, we're the government, we're here to help you and we'll give you the information, there's a whole myriad of reasons why they can say, no, we're not going to give you the information. And so I'm going to show you right now what the myriad of things are that the government can say, no, we're not going to give you that information. Here is just one teeny tiny little section of the federal law. Section 1626, considerations in determining whether production or disclosure should be made pursuant to a demand. So here are 6 reasons why they can say, no, we're not going to give you this stuff. Number 1, that disclosure would violate a statute or a rule of procedure. And believe me, the government can always, hide behind procedural rules. 2, disclosure would violate a specific regulation. 3, disclosure would reveal classified information. But more pertinent to this case, disclosure would reveal a confidential source or informant unless the investigative agency and the source of informant have no objection. So this is the FBI right here, protecting a confidential source or informant. Forensic, a number of episodes ago, you gave us information on, there might be an informant, there might be a second person. So this is one reason why the FBI might be hiding and saying, nuh-uh, we're not going to give you this stuff. Number 5, also pertinent to this case, the FBI could say, we're not going to give you this stuff because disclosure would reveal investigatory records compiled for law enforcement purposes and would interfere with enforcement proceedings or disclose investigative techniques and procedures, the effectiveness of which would thereby be impaired. So, in my view, those are the 2 things the FBI would hide behind. Number 6 doesn't really apply here. They could say, we're not going to give you the info because it would reveal a trade secret. So, that is not really pertinent. So my guess, and I don't know, but my guess would be that they're hiding behind one of those things and saying, we're not going to give you the information.
And number 5, interesting, is a lot of what our viewers, a lot of the people who are saying that's why they're not giving over the information. That's a lot of what we see in the comments, is people saying, oh, well, if they were to give it all over, then that makes it, I don't agree with this. They say that it would make it public for other people to figure out how they did it for copycats. I don't necessarily agree with that, but it's interesting that you pointed that out because it kind of aligns with what I've seen some comments saying.
I agree. And I also like number 4 there for what they might be hiding behind. And I say that because we have the situation where the FBI tip line was open and they were receiving the tips and filtering them, back out into the world. Okay. So with that being said, very well, it could be that they did provide her a summary. And the reason why is because they don't want to provide her the information as to the person, but they did provide the tip. So there could be basically like redactions that have been made and she's looking at it as a summary. But in actuality, it's the full scope of what, is going on there. They just can't give her all the rest of the information. Now, she does seem to think that it is specifically the phone and the car together that they are hiding, whatever that tells you. So whatever information would put the phone and the car together, because she's talking about both of those things.
Well, that's the second TUI letter. My thought was that the first TUI letter was by the state, by Bill Thompson and Ashley Jennings, asking the FBI for information, and the FBI cited 4 and 5 and said, no, we're not going to give it to you. And I think, correct me if I'm wrong, and I may well be, but I think that's why Ashley Jennings hushed up Ann Taylor incorrectly, and they didn't want to admit that the FBI isn't even cooperating with the state because the FBI, doesn't have the goods to support the probable cause affidavit. That was my read on it. I don't know.
I don't know. It seems like, what would be the harm for the FBI to provide the information then? Because
they don't have it. Because they don't have it.
But they didn't put together the PCA, and they're not the ones who went to the judge to get. That was the Moscow Police Department. That was Blaker and Payne who went to go have the probable cause warrant signed. So it just seems like the FBI could actually give the information over and then literally pass the blame onto the people who went and arrested the perp, right? So,
well, I don't know. Maybe you might be right, but then again, on the other hand, I think that Payne and his buddy there were in a hurry. I mean, the networks were every single night after November 13th until the end of the year. These 4 young people are gone, and there's no suspect. Still, here it is, December 1st. It's been 2 weeks. There's still no. There was just so much pressure that they threw the PCA together, and now they're like, we got to get the goods. We don't have the video. We don't have the cell tower reports. Let's ask the FBI, and the FBI is like, what? Us worry? We don't have it. That's my read on it. I mean, I don't know. I think something's going on behind the scenes, and I don't think they whether it's the FBI or the state of Idaho, I don't think they have the evidence to support the PCA.
So is it that you don't believe that they ever had it and gave it to the prosecution either, or like law enforcement? Like, so you don't think that law enforcement or the prosecution has been given a copy of any of the stuff that Ann is looking for? Because I, on the other hand, think that they have. I think that that's how they built their story, whether it's true or not. They must have gotten some kind of information. And I also wonder why they can't just give Ann Taylor some information. Why does she have to get it directly from the FBI if you already have it?
Because
it sounds like they have it.
What she's interested in is what is the evidence that's going to be thrown at her at trial. She wants to know whether it's the Moscow Police Department or the Idaho State Police or the FBI. She wants to know, and she has every right to know, what is the evidence they're going to throw at me at trial. Don't wait until the day before trial and ambush me with this stuff. She has every right to know. And they're like, yeah, we'll get around to it. See number 4 and 5, when we feel like it, we'll give it to you. And that's wrong.
No, I agree. And I guess my question is, why does she even have to get this stuff from the FBI? Why is there not like some copy of it somewhere that she can get from the prosecutor's office? Because
if
wouldn't
the
they also have to have it?
She should also, yeah.
Yeah, that's my point. They have it. She should have it. That's exactly I don't understand why she has to jump through these hoops at all, because it should just, I mean, if I had it and I know that it's going to make your client look guilty, I'd just give it to you.
But Bill Thompson, if you listen to his, I didn't do it. If you listen to what he says, we've given them everything that we have. Oh, wait, no, we've given them 95% of everything we have. These agencies aren't cooperating with us, the FBI. And so he is directly blaming the FBI for his failure to provide the discovery that Ann Taylor is looking for. He's saying, it's not my fault. I mean, he watched Han Solo when Empire Strikes Back. It's not my fault. It's the FBI.
Yeah. And that's why I say I feel like the FBI should at least just provide what they have so that they can at least put the blame back on them again, because they did help with the arrest and stuff like that, but we didn't actively seek out the probable cause again and again, like I think they did. And so therefore, isn't it your fault that he ended up arrested? Isn't it those who had the judge sign the probable cause, the people who provided an affidavit, isn't it their fault? I don't see how this would be the FBI's fault. So whether they have it or not, if the work was conducted at all, I think they should give it to her so that
Well, if Uncle
at
Bill
least
if
they
Uncle
can
Bill
just go
Thompson
straight.
is blaming them, they're
Uncle.
directly at fault. I mean, and why does he have to have this motion to compel secret? Why did they argue for a whole hour? And in my view, the judge had already made up his mind. If you listen to him arguing the state's case, he wants this thing sealed. And I think Thompson has egg on his face because, on the one hand, he wants to say, oh, we've given him everything. And on the other hand, he's going to say, well, we don't have everything because it's the FBI. It's not us. No, maybe we didn't give him everything. Maybe we only gave him 95%. I mean, he doesn't want this in open. There's already been an issue, a polite way of putting it, over the whole issue that came up over the survey. Mr. Thompson, said, oh, we want this in, this survey has got to stop. I mean, he's asking these questions that are tainting the jury. 400 people have been tainted. And then he goes on nationwide YouTube, the judge's YouTube, and reads the questions. I mean, so I think he wants to keep these things private. And I don't think the FBI is cooperating with him. And yeah, a lot of us who know the FBI's history in the greater Boston area have very little faith in the FBI as a professional investigative agency. And I don't think that they have it. Now, they did a great job in the Murdoch case. They did a fantastic job in the Murdoch case. But in this case, I don't think that, and it's only my opinion, but I don't think that the state of Idaho has the evidence to support the probable cause affidavit. I think it'll crumble.
It very well could. It very well could. I do wonder if the rest of the information that she is looking for is all the exculpatory information. And maybe this thing will turn on its head. But all at once, I have to look at it. And I do see that she has mentioned exculpatory information a number of times. There are a number of things she's saying are flawed. When she mentioned Bethany, she was saying that Dylan Mortenson's eyewitness identification must be flawed. She said that the IGG either wasn't done or was flawed or done illegally. The cast, the car identification. There's a number of things that she said were done wrong. So she does have a lot of things in order for her to say that they were flawed. But I do wonder if there's something that is being stuffed away and stowed away. I have always thought that the thing that was being stuffed away and stowed away was the other person. So maybe that's why the portions of the video are missing. Maybe let's just exaggerate for a moment. Maybe that white car pulls up and they do see someone get out while the white car is still circling around. And maybe that's something she doesn't have. And that would definitely show you possibly that although her client may have even been a driver, and I know she says it wasn't his car, but the point is that even if he was a driver, then he's not the actual attacker in the house, is he? If someone else got out just before that, and she can show you that on the video, but if she's missing bits and pieces, then she can't show you that. And
right.
So everything she's asking for is very, very valid. It's not just valid for her client, but it's valid for the justice for the kids. It's valid for their families. Their families should know. They shouldn't. And I don't see that we'd go to trial and miss out on those bits and pieces. At some point, they would have to be shown. But that's not the time that they should find out that there was someone else involved and that Brian was just a driver.
No.
That's not the time. So
let's change subjects. We'll come back to this. Let's change subjects a little bit. I was just going to point out, I don't want to go too deeply into this because I'm going to do a whole episode on this in the very near future. But my contention is that this fight over the alibi is just a sideshow away from these really significant things that you're talking about now. And that is because, Bill Thompson raised it as an issue and said, "Oh, the alibi is phony baloney." He then filed a follow-up when Mr. Kohberger updated his alibi and said, "Well, I have a habit of driving to Wabaye Park, and I do like to run, and I do like to look at the stars. Not that I was doing those things on that night." And Prosecutor Thompson followed up by saying, "That's not an alibi. We want to strike it. You need to No, we need to, like somebody told me on the phone this morning, we need to calm right down, because the Constitution of Idaho overrides this statute that they have. And even if the statute is so important, look what it says. Mr. Kohberger can amend this as long as it's in good faith right up to the time of trial. Section 3 of the alibi statute in Idaho says that even if during trial a party learns of an additional witness whose identity, if known, should have been included in the information furnished under the above sections or subsections of the alibi statute, the party shall promptly notify the other party or his attorney of the existence and identity of such additional witness. And then also the final section of the alibi statute says, for good cause shown, the court may grant an exception to any of the requirements of some sections 1 through 4 of this section. And what does that mean? That means that, Prosecutor Thompson is really pushing the issue of that alibi is no good. We've got to kick it out. No, we all need to just calm down, because even the state constitution overrides the statute. But even so, the statute says, look, as long as Mr. Kohberger was in good faith, if he doesn't find a witness until the very end, that's okay. So I just think that the whole fight over the alibi has become a little bit of a sideshow.
Mm-hmm. I agree with that.
I do as well. Once he, provided his alibi, to even respond, I thought that was pretty petty of Mr. Thompson. He said he was in the park, like out in a remote area, who in the middle of the night. So who would even be the witness? So as far as bringing a witness to support that alibi, it would be someone like his expert. Of course, there's going to be an expert. How else is he going to support that alibi? It's
right.
So it's not like there's going to be a random other jogger that was out there that was like, oh, wow, I actually high-fived him. I remember.
Right. Right.
It's not going to be that. So I agree. It became like almost like a sideshow. Yeah. Like
it is a sideshow
because it's nothing to even entertain. There's not going to have been someone else out there. And the chances, okay, at all, of either of the three of us, right? Say we were out there, we're jogging, and we ran right past Brian that night. Would we even remember?
Right. Yeah.
So there you go.
I mean, I'm divorced now and single at this time, and my daughter moved out. So, I'm a single guy. I mean, if somebody, for God's sakes, committed a horrible, heinous crime in my neighborhood, what's my alibi? I mean, I went to bed last night. I was tired and I didn't wake up till, 5, 6 o'clock. So what is my alibi for last night at 3 o'clock or 4 o'clock or 2 o'clock? I mean, so don't push me. Don't push me. I'll think of something.
For what it's worth, on Wednesday, I went on a long drive with my partner, and we were just driving around aimlessly and went to walk in a park afterwards. So if a murder happened at that point, I'm Kohbergering it off. I'm doing. I had him at least.
People do drive around aimlessly. I mean,
our commenter is always complaining about the gas prices in America when we talk about the driving around aimlessly. And here I am now, after me saying I don't do it. All right, we're driving. It was a great drive.
If anything violent happens in the next 6 months, I'm going to blame it on you having been out there.
No, you guys, my alibi now.
So I mean,
I planned this all.
I think the whole thing is really a sideshow. So let's get on to another sideshow, and the next sideshow is this push. Let's hurry up with the trial. I mean, there have been voices very recently out there saying this is a sideshow. This Ann Taylor, she's coming up with this phony alibi and these phony witnesses, and let's hurry up and get this thing to trial. Again, I guess that's my mantra for the day. We all need to calm down a little bit, because here are 6 cases that took longer to go to trial. Lori Vallow, 3 years. Chad Daybell, from the time of the crime to trial, 3 years plus. James Crumbly took 2 years and 2 months. Hannah Gutierrez Reed's trial took 2 years and 4 months. Adam Montgomery's took 4 years and 2 months from the time that poor little Harmony met her demise at his hands until his trial. And I'm sorry, this is kind of a repeat slide because we used the same facts previously. And one of our viewers commented, Attorney Myers, what about suitcase Sarah? So it's been 4+ years since Sarah Boone allegedly stuffed her boyfriend in the suitcase, and there's still been no trial. So, it just my message to people that say, hurry up, hurry up. On this, I totally agree with Judge. He said, we only want to do this right. We only want to do this once, and we better do it right, not fast. So that's my little bit of a rant on rushing to trial. I don't know if anybody has a comment on that before I should go to our final little bonus slide.
I do. I want to let you, I want to give something to you. So the other day when I did the video on Richard Ross, that had happened in September of, thank you. That had happened in September of 21. And he pled not guilty, and he changed his plea in December of 23 to guilty by way of Alford. So assuming that the entire time he was being defeated and worn down, Mr. Ross took 2 years to change his plea to guilty. So assuming Brian was really innocent, is really innocent, this could take a while then, because it took 2 years alone over 2 years alone for what was apparently a guilty man to say, I'm guilty by way of Alford. So just think about that. It took 2 years for Ann Taylor to get her client to change his plea in the other situation, because she tried, she went through some of the same steps and made sure everything was done right before she allowed for her client to just say, I'm guilty, so if her client is truly innocent, she's going to go through and let this take however long it needs to.
Right.
I will also say, though, that rushing doesn't always destroy the case. They did rush the case with Mr. Murdoch, and he is so guilty. So
we agree on something.
So rushing doesn't always kill the case, but in some cases, the wait ends up being well worth it for the families of the victims. And in some cases, the wait is what shows you that you were about to accept guilt for someone who wasn't guilty. And that really isn't going to do you any justice. So provide a little patience and a little understanding that the criminal justice system doesn't have a laying out time frame that these things are actually always done in. They give you estimations, but there's always a loophole to get around that date and that time and that expiration. So just be patient and, hope that if the outcome is what it's supposed to be, that's what it will be.
I would add to that the court process is about the guilt or innocence of a person who has been accused. The court process is not about giving closure. We talked about the case of Mary Lou Arruda. That case was tried 4 times in Massachusetts from the date of the crime in the 1970s until the final appeal in the 2000s. The case was tried 4 times, and there were 22 appeals. And on the 22nd appeal, when the case was finally all over, Mary Lou Arruda had been, a 15-year-old girl. Now she would have been a middle-aged woman. Her mother said, no, I don't feel any closure. So, if people are looking to the judicial system for closure, they're looking in the wrong place. They need to look into themselves. I know certain people who say they're looking for closure have also, expressed deep faith in their faith, and that's fine. That's where you go for closure. The court system, and I know this is not a popular view, but the court system is about whether the guy is guilty or not, and that's all. So I don't think they should look for closure here. You guys want to jump all over me, or should I move to our final point here?
No, go ahead.
Okay.
Yeah.
All right. Do you remember our last episode? We pointed out, and I think a lot of people missed it, but in that hearing, in the very last day of April 2024, Ashley Jennings shushed Ann Taylor. She shushed her. And before I even said this on our podcast, I played that over and over and over and over again. She shushed her. But when we did that episode, people accused me of having bad hearing. And they said, no, she didn't say hush. She said judge. Well, okay, I went through all of our commenters, and our commenters, the final word from our commenters is 35 of them say she said hush. Only 8 of them say she said judge.
I agree. I think I heard hush as well. It just seems like it was either hush or a very short judge. Judge just doesn't.
It's a harsh word.
It was either hush, I'm pretty sure, or a very short judge. But I don't think it was the second. I don't know why.
Yeah.
I just don't.
Judge, hush.
But also, I feel like
judges.
right, you don't really like address, and you also don't really like address the judge in such a startling tone.
No.
So
Judge.
I don't know. Judge. It's just I don't know. So I didn't like it.
I meant to bring in a copy of my Maui trial techniques book, which is the book on how to try a case, and it's by Maui. And I know it's probably been updated a million times since my version, which is this thick. It's just court rules. If something occurs to which you object, you direct your comments to the court directly. The proper thing to do if somebody says something you don't like, and I've done this to other attorneys in their openings or closings, and I've had it done to me by other attorneys in their openings, closings. The correct way to approach this is to stand up, which I'm not going to do because I'll fall on my face. Stand up, objection, motion to strike. That was the proper way to handle that. When you're an attorney in open court and your case is going and you're at the counsel table, if something happens you don't like, that's the correct procedure in all states that I'm aware of. You say objection, motion to strike. And the second point is attorneys aren't supposed to address anybody else except for the judge. You don't have crosstalk with the other attorney. You don't talk to the witness unless you have the permission of the court. So her remedy, her professional rules of conduct in the court, the correct way to proceed would have been to say, Your Honor, objection, motion to strike. But to say hush to another attorney, I've just never seen that.
Now, I want to point out that might be why she didn't actually look at Ann. She literally didn't break eye contact with the judge, and Ann Taylor kind of had to like roll her neck and figure out like where that even came from. And then she stared for a moment because Ashley didn't actually break eye contact with the judge, but she definitely, I feel like, hushed Ann Taylor. But maybe that is supportive of the fact that she did kind of shoot out a quick judge, because she was like, definitely the eye contact with the judge was very intense. It's exactly what your little thumbnail of her is there. And she didn't ever look over at Ann. It was really, really strange.
Nonetheless, you address yourself to the court, and you don't say hush. You say objection, motion to strike. And that if you have a loud voice like I do, that stops the activity. And that's the other thing. If there's an objection in court, the other parties are instructed to just stop what you're doing.
And it does feel weird, doesn't it? When you get an objection, the moment becomes kind of weird. That hush was weirder than any objection I've ever heard in my life. That hush was like so weird. It was so cringy. Yeah.
It was unusual. I've never seen it before. I've never done it before. I think I said in a previous episode, I felt like it. There have been times when opposing counsel was saying stuff I didn't agree with, and I felt like saying hush. But like I said in a previous episode, You keep it in here, then you go to the gym and you punch the punching bag.
Punching bag's gonna be whoever tells me to hush.
Yeah. Yeah, that's what some of our commenters said. I would have, I would have this.
I'm not an attorney.
I would have threw my legal pad at her.
Yeah. I would have thrown the book at her. Look at all these books I have behind me. I'll grab one of them and throw them at her. Although we have fewer and fewer books these days.
Mm.
All right, guys, any closing thoughts before we move on?
I'm all good. I mean, thank you so much, Forensic, for joining us today. It's always a pleasure having you on, and getting to hear your opinion is always a joy. Thank you so much for joining us today. For any of the commenters, thank you so much for watching. Like, comment, and subscribe, and we'll see you in the next one.
Thank you, Forensic. Have a good one.
Have a good night, guys.
You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
And that's that.
And that's that.
Did everybody get their dog?
This podcast is going to the dogs. You had your dog up during. You had your dog up in your lap during the close there, and what did the dog run away? He got scared.
No, he likes to lay on the floor next to me and like peek out the window. So he's he's kind of doing that right now. If he
Did
can
you
find
shush?
anything,
Did you shush the poor dog?
no, if he can find anything to bark at out there, he'll have a blast. And even if I shush him, he doesn't shut up. No objections. He'll shut him up.
No.
This guy's learning to shush. This guy likes to yap a lot.
Aww,
He looks tired right now.
he's
What's-
cute.
What's his name?
We got little Zuko, our little rescue here. He came home
Oh.
in February.
Go. He's cute.
He's just a little dog.
I remember when he was a lot littler when you first got him.
6 pounds. I can hold him in one hand.
Little Puzz. He's so cute and so fluffy.
My dog didn't want to come in today. Usually she comes in and a lot of times, but she didn't want to come in today. She didn't even want to go for a walk. She was stubborn. She just wanted to lay on the couch and watch TV.
Aww.
Yeah.
Lainey, you said your dog weighs 6 pounds?
This one, yeah.
Yeah, mine is like 56 pounds. I just almost broke my back trying to lift him up.
A tenth of the weight here. Yeah, no. Sometimes he's 5 pounds 9 ounces or something.
Aw, tiny like my mom's dogs. That's so cute.
And that's that.
And
That's
that.
that.